So thank you so much for being here. We know we had a long day of presentation, so we appreciate it's always hard going last, but this is going to be a great panel, so we thank you for your time and your attention. And so since we've been having presentations all day and we've heard a lot of stats and a lot of numbers, this one is going to be more conversational. So we're just going to have a conversation amongst each other, and then we also welcome you to ask the panelists any questions. Just to introduce myself, my name is Ebony Ruland, and many of you might, thanks Raj. So many of you might know me from the University of Minnesota. I was recently at the Robina Institute, and now I'm at the University of Cincinnati. So now I'm a bearcat instead of a gopher. But Robina still invited me back, so that was great. But I'm going to have each of the panelists introduce themselves and talk a little bit about probation within their jurisdiction, because we've been talking about mass incarceration and mass supervision, and these things, and mass incarceration often happens on a state level or a national level. But when we talk about mass probation and community supervision, it's very jurisdictional. Probation happens at a local level. Hennepin County probation is very different than Ramsey County probation, even though we're right next to each other. So we're going to just set the context of what probation is like in each jurisdiction, focusing specifically on probation conditions, because again, sometimes I think there's this idea that probation is a benefit, it's easy, people are out in the community. But from our research at the Robina Institute, we have found that probation can actually be quite onerous for people. It can be quite difficult for people, and it can be a feeder into this incarceration through violations and through revocations. So I'm going to ask each of our panelists to just introduce themselves, talk about how they work in the area of probation, and then talk a little bit about what your conditions are and your lengths of probations are within the jurisdictions that you're familiar with and working with. So we'll start with Dr. Dillon from Dallas County.
Thank you. Good afternoon. Well, I met Ebony, I think it was 3 years ago. I would have never thought I would have been in Minnesota, but here I am from Texas.
And he almost didn't come because he said he doesn't want to come in December. And I said, it's not that bad.
Well, I'm from Dallas County. I am the deputy director there. Been in Texas about 17 years. Initially, I am from California, so I have not done my 20 yet in Texas, but I think I'm close to being a Texan. Dallas is unique, as is Texas in general, when you're considering probation. I know Ebony was just talking about on a local level, but for Texas, we're kind of quasi-local, quasi-state. So to explain this for you, we work under the jurisdiction of the judges, our court orders and our conditions. However, our funding comes from the state. We get no funding from the county whatsoever. And I know there was a discussion earlier where I think that was kind of stated, but to clarify, Texas does not. I know there is, since we are here at the Robina Institute, there's a lot of discussion about fees. How Texas works, fees are a part of supervision. The state in general gives us Texas is set up on a biennium, which means every 2 years we get funding, and the state has given us about $650 million to all the probation departments, and there's about 124 throughout the state. So to run probation in Texas is $1 billion. So where does the other 300 so million comes from? It does come from probationers. And that's something we're still having to work on and try to figure that out. However, in Dallas, which is a very progressive county, individuals are not revoked for not paying probation fees. That does not happen. The number one reason a person is revoked in Dallas is new offense. It's about 40%. After that is absconders. Now, some could say people probably absconded because fees or whatever else, but that's around 36%. And then the other is compliance with treatment, and that's somewhere around 13% end up back in prison because they just wouldn't comply. In Dallas, we have let me go back one more thing. Let me say one thing on fees. It probably does occur, but I know it's not even at 1% for Dallas, about 0.3% where it may get revoked. And that's usually for some victim compensation is the reason the person would not pay, and so they finally filed a revocation on them. Our standard conditions, we have around average between 12 and 15. Now, if I gave you a list of all of our conditions, it's embarrassing to say, we probably get up to around 120. However, that's not what one individual get. They just run the gamut to make sure if this person needs a specific program, we have a list for that person. But we're very treatment-oriented in Dallas. To give you an understanding of how large we are, there's 44,000 probationers under our supervision. I have around 300 or so officers. So caseloads are running around 130. And to go back to say how progressive we are, we have 17 specialty courts in Dallas. Recently, CSG, Tony Fabello, was in our county. They're looking at to see how successful our specialty courts are. Because, as you said earlier, specialty courts can be onerous also because there's a lot to accomplish when you're in a specialty court. So I don't know if I'm missing out. Have I covered enough for you?
I have some more questions, but we'll continue with the introduction, and then I'll come back.
Good afternoon. I'm Judge George Stevenson. I'm a Ramsey County District Court judge. I've been on the bench for 16 years. Prior to being appointed to the bench, I was the chief prosecutor for the city of St. Paul. I've also been in private practice, and before I moved back to Minnesota back in the early 90s, I was a federal defender in Chicago. My current assignment is a felony caseload. I do have some misdemeanor cases and gross misdemeanor cases that appear in my courtroom, but most of my casework now is felonies. We work very closely with our probation folks. Every time a person pleads guilty or is found guilty in a case that requires, in a case that is either a gross misdemeanor or a felony, we require that a pre-sentence investigation report be done. That report is done by our probation department. That report, those reports usually give us a recommendation. If they're felonies, the recommendations usually comport with the state sentencing guidelines, but they'll also take into consideration any plea agreements. Those reports give us a lot of information about the offender, give us information about victim, if it's a victim-related crime. That report will also lay out specific conditions of probation that are being recommended, and then it's up to the judge to decide which of those conditions will be imposed. I've heard Dr. Dillon talk about some conditions of probation being onerous for probationers. That's true. I do believe that there are some folks for whom probation is just not a viable option. Those are folks who, for whatever reason, just are reluctant to, how can I put this? Folks who are resistant to being told how to live their lives, who are resistant to being told what programming they have to participate in. Folks who want to do their own thing, and sometimes folks who just have difficulty complying with conditions of probation. When I have folks like that appear before me, while I encourage them to comply with conditions of probation, and I try to fashion conditions of probation in a way that they are more likely to be successful, sometimes I'll tell them, you might want to just execute this sentence, because I just don't think that you're going to make it on probation. I am probably one of the more moderate judges on our bench. I do give folks chances. I take chances on folks. I do like to think outside the box. I believe that my role in this process is to put folks in the best position to be successful, and the best position to be restored to the community as law-abiding, contributing members. And sometimes that means doing things that's a little bit different than some of my colleagues do. And I'm happy to talk to you about that after Professor Kringle, is it Kringle?
Close, Kringle.
Kringle introduces herself.
Thanks. My name is Cecilia Kringle. I teach at the University of Wisconsin Law School, where I also am a proud alumna. I'm lucky to come from a school with a rich tradition, like the University of Minnesota's as well, in criminal justice. And after spending a number of years working in federal courts, when I went into the academy, my interest was already focused on correctional issues. I was alert to the problem of mass incarceration, and it seemed to me that the most pressing question to be answered was, what is the alternative to custody? If America is addicted to incarceration, what else is there to offer? And it seemed to me that community supervision was the most readily available and commonly used alternative, and that we didn't know nearly as much as we ought about how it was functioning in the United States. Legal scholars had examined community supervision at length in the 1960s and 70s, and then largely abandoned it as an area of study. So I began my academic work by spending a wonderful summer in the field with U.S. Probation and Pretrial Services in the Western District of Wisconsin. And as any of you who know much about federal probation know, most of the time of federal probation officers is not actually spent supervising probationers, because although it used to be the case that the majority of federal cases, like state cases, drew probation as a disposition, in fact, in recent years, the percentage of cases in the federal system that result in probationary sentences continues to fall. It's now below 11% of federal cases in which we see probation as a disposition. So federal probation officers actually supervise a mixed population of both probationers and those on supervised release, individuals who have spent a period of time in custody in federal prison before returning to the community. As I worked with federal probation, I was interested in the differences in the structural composition of the federal system versus many of the state systems. And over time, as I worked in other states as well, a little bit in Texas, I'm currently working some in Massachusetts, and studying my home state of Wisconsin as well, one of the things that I think is most important to realize is that there is incredible diversity in the structure of probation on a number of levels, as well as the laws that govern it. So one of the most important choices to be made is whether probation is to be a local entity or a statewide entity. As you heard, in many places it's mixed. In the federal system, for example, administration occurs at a national level, but probation officers report to their local district court judges. So you have both the localized and the national component. In Wisconsin, as in the federal system, we have mixed caseloads for those probation officers who are employed by the state in that jurisdiction. And so state community corrections officers who don't report to courts at all supervise a mixed caseload of probationers and those on what we call extended supervision, which is another form of supervised release. In Massachusetts, the probation agency is separate and recently realigned with the courts from being previously an independent agency. Those kinds of differences matter because who you report to, if anyone, will affect internal incentives. It can affect funding structures, it can affect caseload size, and it can also either increase or diminish the diversity you see within a single jurisdiction in its practice. In addition to the administrative structure of probation, I think an area that doesn't receive as much attention as maybe it ought to is the legal structure for imposing conditions of supervision. As you heard, the number of conditions will vary in any given case. In most jurisdictions, there are at least a few standard conditions that are required by state statute. The state legislatures determine those conditions, and there's no discretion for any other individual, either judge or executive branch official, to decide whether those conditions are appropriate. Then additionally, in most jurisdictions, judges have discretion, usually wide-ranging, in determining the number and kind of additional conditions of supervision that ought to be placed on an individual. In some jurisdictions, Wisconsin is a good example of this, in addition to the judicial and state legislative layers, we also have a layer of executive discretion. in which probation officers themselves are legally authorized to add additional conditions of supervision, not specified at the time of sentencing, but rather added during the supervision process, that probationers must comply with. Why does that matter? For a lot of reasons, particularly because, of course, community supervision is a form of conditional release. And so any violation of any condition at least confers legal authority to return someone to incarceration. And if you are a criminal justice reformer or administrator who wants to think about the number and kind of conditions that are being imposed, knowing the legal structure by which different entities can impose conditions will affect the routes you take to change current practice. So I think I've said enough about sort of the variety of structures that exist, and Ebony, I think, is going to get us into more of the specifics right now.
So we know that in the United States, and even here specifically in Minnesota, that a lot of people are under probation. So we see that with the conversation around reversing mass incarceration, that there's a call to place more people on probation. So I'm curious, from your perspective, and there's no order, so answer as you feel, is that a good thing? Is it a good thing that we're looking to place more people on probation as opposed to incarceration? Or are there concerns with probation? Sometimes when we talk to people who are incarcerated, they said, I'd rather go to prison. I chose prison over probation. Prison's easier. So what do you guys think about this idea that probation, we should be moving more people away from prison and onto probation? Anyone?
Yes, I think that's valid. It's difficult for me to see many benefits in an individual, as I've heard today, be caged. I understand there is a need for us to protect the community, but I think it's a small portion of individuals that do need to go to prisons. Probation is here to make a difference, and I would doubt it highly that I have officers that are there to just nail or jail someone. And when you think about Texas in general, on one spectrum, we're talking about the death penalty, and then we're talking about, on this end, probation. And we've made a lot of positive changes in Texas. If you look at probation just 7 years ago in the state of Texas, I think we've dropped over 150,000. If you look at Dallas County, just for us, in the last 7 years, we lowered it by 9,000. Now, I'm not here to say that there's not more we need to do, but we have to at least recognize that there is a benefit of probation. And again, is it onerous for some people? Yes. And then I know there's that argument about responsibility and accountability, but I think for us, we believe we're making positive changes.
Most of the folks that I see in my courtroom are relatively